I get forgotten. I guess is my personal thing. I get forgotten if it takes the Speaker of the House or the Senate Majority Leader for me to get an answer. And there are dozens of senators like me whose concerns with not getting information are simply never going to rise to that level. Sorry, John.
No, very valid point. I mean, it has gotten worse. And I don't know whether the abuse of executive privilege tracks exactly the increase in partisanship in our country, but I bet it's close. I mean, it seems to me, and you folks would know better than I would, but because you've studied it, but inevitably there is going to be some friction, and there should be some friction. And I don't think our objective ought to be to make a good faith cat love a good faith dog. They're not supposed to under our separation of powers. But there's been a lot of bad faith, and I don't know whether the answer is to codify the so-called Reagan memorandum. You can't. I mean, you can say the OLC be a neutral arbiter, but you know we live in a real world. I don't see any way to get a quick resolution without involving the judiciary. I just don't, as a practical matter. Now, should we have to? No. But we don't live in a perfect world. And I think that if you did have some sort of mechanism to get the judiciary involved, you would have a lot of people in both the legislative branch and the executive branch have an epiphany and say, you know, maybe we ought to try to work these things out on our own. So I guess my question is, let's assume for a second and I could be wrong, okay? You could convince me that, as the professor said, maybe the worst thing we could do would be to involve the judiciary. My mind is open. But let's assume at some point we do have to involve the judiciary. How would you design that? It would have to be quick, and it would have to be accessible. You shouldn't have to get the majority leader or the minority leader's permission or the speaker's permission. For the BIPs like me, barely important persons, I'd like to be able to have access to do it too. But tell me how you design it, Professor Shaw.
Well, maybe I'll say in general that there may be a way between the sort of two paths that we are outlining, one of which is essentially to cede final authority over the resolution of these disputes to the judiciary, and the other which is to say the political branches just need to work it out on their own. Maybe a middle path is to design an expedited judicial resolution procedure that is rarely invoked because its very existence forces everyone to the table to actually resolve these disputes. So maybe it occasionally is invoked, but it is not.
Don't you think you'd have to invoke it a couple of times?
Sure, but hopefully that would be enough, and then you wouldn't. Sorry to interrupt, Senator, but yeah. So that maybe you do a couple of times, and then it is clear there will be, consequences for failure to negotiate in good faith and to reach reasonable accommodations. And I suppose it would just be whether a committee, a chair and a ranking member together, a single member of a committee. I guess I haven't thought carefully enough about who could initiate the process to speak really definitively about it here, but that would require, an expedited resolution, potentially the chairman's suggestion of 30-day status conferences until some kind of resolution is reached, and the fact of the process would serve a forcing mechanism. So, my general instinct is that the less judicial involvement, the better. I don't think either political branch should want to cede the ultimate authority over these important constitutional questions to the judiciary, and yet we do seem to be at a stalemate moment in which some third party may need to be pulled in.
I don't think the judiciary will like it, as the Professor Mascott said, but
I think that's right. Yeah, I don't think the courts would want this role, quite frankly. Political matters should be solved between the political branches. And there is a long history of an accommodation process between the legislative and the executive in which these disputes have been resolved by good faith negotiations and compromises over time. So,
Over time is the key
right.
expression.
And overtime is okay, I would say. I don't see why there should be a rush to move things forward necessarily. Part of the separation of power system means that things oftentimes have to move very deliberately and take their time, and that's quite natural to the process. And I don't think that there's anything wrong with that. So I don't see the courts wanting to get involved in this. I worry about what it says about the nature of the process, that some would believe that the courts need to step in and resolve what the legislative and executive can't do themselves.
Well, I guess because we start from the proposition that this doctrine has been developed by courts, and that's how we are. Marbury v. Madison, what the law is. Senator Hirono.